States. You have the floor, Madam.
Mr. President, esteemed members of the Court, it is an honor to speak before this Court on behalf of the Kingdom of Spain. Spain, pursuant to the invitation by the Court in accordance with Article 66 of its Statute, presented a written statement on the 25th of July 2023. The current oral intervention aims to complete that written statement and furnish the Court with some elements that, from the Spanish point of view, may be of help in discharging the request made by the General Assembly. Spain, in this oral intervention, will amply rely on the advisory opinion rendered on July 9, 2004, on the legal consequences of the construction of the wall in the occupied Palestinian territory. As it is of the view that most of the Court's arguments and replies to be found in this opinion are of paramount relevance and are also applicable to the present case, we are going to address the Court in two main blocks. In the first one, we will briefly analyze the jurisdiction of the Court and then examine the international law applicable to the case, affirming that Israel is bound by this law. In the second one, we will elaborate on the particular issue of international responsibility of states in case of serious breaches of international rules that protect the basic interests of the international community as a whole. This second part will be dealt by Professor Mr. Ripoll Carulla, head of the International Legal Office, while the first part will be dealt by Mr. Emilio Pin, deputy head of that International Legal Office, to whom I kindly invite you to give the floor now. Thank you very much.
I thank Mr. Lopez. I now give the floor to Mr. Emilio Pin. You have the floor, sir.
Mr. President, esteemed members of the Court, it is an honor to speak before this Court on behalf of the Kingdom of Spain. The competence of the Court to give the advisory opinion requested by General Assembly in its Resolution 77/247 is based on Article 65, paragraph 1 of its Statute. The General Assembly, which seeks the advisory opinion, is authorized to do so by Article 96, paragraph 1 of the Charter. The questions are directed to the legal consequences arising from a given factual situation, considering international law. It is indeed a question of legal character. Therefore, Spain is of the view that the Court has jurisdiction to give the advisory opinion requested by Resolution 77/247 of the General Assembly. The lack of consent to the Court's contentious jurisdiction by an interested state has no bearing on the Court's jurisdiction to give an advisory opinion. The goal of the request before the Court is to obtain from it an advisory opinion which the General Assembly deems of assistance to it for the proper exercise of its functions and responsibilities. Mr. President, distinguished members of the Court, both Israel and Palestine are under the obligation to observe the rules of international law. In the 1967 armed conflict, Israeli forces occupied all the territories that had constituted Palestine under the British mandate, including those known as the West Bank, located east of the Green Line. This occupation was immediately and unanimously condemned by Security Council Resolution 242, which underlined that, and I quote, all member states, in accepting the Charter of the United Nations, have undertaken to act in accordance with Article 2 of the Charter, end of quote. The principle of prohibition of the use of armed force is one of the fundamental principles of international law, and, as formulated in General Assembly Resolution 2625, is accompanied by the following corollary. I quote, "No territorial acquisition resulting from the threat or use of force shall be recognized as legal." End of quote. The Court, which has on several occasions affirmed the importance of this principle, has not hesitated to apply this principle to the Israeli occupation of the Palestinian territories. In the advisory opinion on the legal consequences of the construction of a wall in the occupied Palestinian territories, the Court has recalled the principle of the inadmissibility of the acquisition of territory by war. The Court concluded, and I quote, "Under customary international law, they were thus occupied territories in which Israel had the status of an occupying power." End of quote. Finally, the Court added, I quote, "Subsequent developments in these territories have done nothing to alter this situation. All these territories, including East Jerusalem, remain occupied territories, and Israel has continued to have the status of an occupying power." End of quote. Although Israel finally withdrew its civilian and military presence from the Gaza Strip in 2005, it has maintained full control of its borders, coastline, and airspace ever since. Consequently, as the Security Council has affirmed, the Gaza Strip constitutes an integral part of the territory occupied in 1967. The Court concluded that Israel's settlement policies in the OPTs, the measures taken with regard to Jerusalem, and the construction of the wall, I quote, "have been established in violation of international law." End of quote. Not only because they are contrary to the Fourth Geneva Convention, but also because they prevent the exercise by the Palestinian people of their right to self-determination. In its construction, the Court points out that the wall, the temporary nature of which is open to doubt, is accompanied by a regulatory regime aimed at annexing the occupied territories. This aim constitutes a serious violation of the rules of international humanitarian law incumbent upon Israel as the occupying power, has the effect of violating the right to self-determination of the Palestinian people and the human rights of the inhabitants of these territories. These statements are also applicable to the Gaza Strip. Israel's withdrawal from Gaza in 2005 has not meant that the occupation of the territory came to an end, and Israel has retained effective control over the territory through its control of airspace, territorial sea, and external land boundaries. The extensive documentation submitted to this advisory procedure demonstrates that 20 years after the Court's opinion, Israel continues to implement its policies, prolonging the very serious violations of international law found by the Court. Mr. President, distinguished members of the Court, on 3rd October 1991, Israel ratified both the International Covenant on Economic, Social and Cultural Rights and the International Covenant on Civil and Political Rights, as well as the United Nations Convention on the Rights of the Child. As stated by the Court, the protection offered by Human Rights Convention does not cease in case of armed conflict. Regarding the territorial scope of those instruments, they are applicable in respect of acts executed by a state in the exercise of its jurisdiction outside its own territory. That is, that they apply both to territories over which a state party has sovereignty and to those over which that state exercises territorial jurisdiction. Those elements concur in this case. Therefore, Spain considers that those instruments are applicable within the OPTs. As stated by the Court in its advisory opinion of 2004, the territories occupied by Israel have been now, for over 50 years, subject to its territorial jurisdiction as the occupying power. In the exercise of the powers available to it on this basis, Israel is bound by the provisions of human rights law, and furthermore, it is under an obligation not to raise any obstacle to the exercise of such rights in those fields where competence has been transferred to Palestinian authorities. Having determined the applicability of human rights law within the occupied Palestinian territory, it is time to seek whether Israeli policies and practices referred in paragraph 18A of General Assembly Resolution 77/247 have violated those rules, and therefore have infringed the human rights of Palestinians living in the territory occupied by Israel. Among those rights that are being violated are those of Articles 17, paragraph 1 and 12, paragraph 1 of the International Covenant on Civil and Political Rights. Also, the Special Rapporteur on the situation of human rights in the Palestinian territories occupied since 1967 has underlined in her latest report to the Human Rights Council that Israeli forces often detain individuals without charge or trial in what has been denominated administrative detention. Administrative detention is permissible only under very strict circumstances and must always be carried out in line with the protection afforded under international law. Palestinians in the OPTs are subject to a system of jurisdictional fragmentation in the context of a structure of institutionalized discrimination. Israeli military courts enforce military law upon Palestinians, while Israeli courts apply Israeli civil law to Israelis, including settlers. Regarding the International Covenant on Economic, Social and Cultural Rights, there are several provisions affected by Israel's policies and practices in the OPTs. For example, the right to work, protection and assistance accorded to the family and to children and young persons, the right to an adequate standard of living, including adequate food, clothing and housing, and the right to be free from hunger, the right to health, and the right to education. Similar provisions can be found in Article 14, 16, 27 and 28 of the United Nations Convention on the Rights of the Child. State parties to the Convention on the Rights of the Child, according to its Article 2, shall respect and ensure the rights set forth in it to each child within their jurisdiction. Of particular concern are the detention, interrogation, prosecution, and imprisonment of numerous Palestinian children by Israeli occupation forces, practice that is contrary to Article 37, paragraph B of that convention. Certain policies and practices of Israel in the OPTs impose restrictions on the freedom of movement of the inhabitants of the OPTs, and deprive a significant number of Palestinians of their freedom to choose their residence, and have, as well, repercussions for agricultural production through the confiscation and destruction of agricultural assets. On the other hand, the population of the OPTs is experiencing increasing difficulties regarding access to health services, educational facilities, and sources of water, impeding the exercise by the persons concerned of the right to health, to education, to water, to sanitation, and to an adequate standard of living. All these difficulties and restrictions infringe a number of rights of Palestinians residing in the territory occupied by Israel, which cannot be justified neither by military exigencies nor by the requirements of national security or public order. Mr. President, distinguished members of the Court, the International Law Commission, in the report of its 73rd session, has referred to the basic rules of international humanitarian law as having the status of a peremptory norm of general international law, jus cogens, with the legal consequences that that status may entail. The provisions of the Hague Regulations, annexed to the Fourth Hague Convention of 1907, to which Israel is not a party, have become, nevertheless, part of customary international law. Particularly pertinent in the present case is Section 3 of those regulations, which concerns military authority over the territory of the hostile state. Furthermore, the Fourth Geneva Convention, to which Israel is a party, is applicable in any occupied territory in the event of an armed conflict, and, as the Court has assessed, it is applicable to the territories occupied by Israel since 1967, including East Jerusalem. Regarding Israeli settlements, Article 49, paragraph 6 of the Fourth Geneva Convention provides that, I quote, "The occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies." End of quote. It prohibits also any measure taken by an occupying power in order to organize or encourage transfer of parts of its own population into the occupied territory. Since 1977, Israel has conducted a policy and developed practices involving the establishment of settlements in the OPTs, which are in contravention of the aforementioned Article 49, paragraph 6. Therefore, the Israeli settlements in the OPTs, including East Jerusalem, have no legal validity and constitute a flagrant violation of international law and a major obstacle to the achievement of the two-state solution, as stated repeatedly by relevant UN Security Council resolutions. The establishment of the Israeli settlements in the OPTs is tending to alter the demographic composition of that territory, contributing to demographic changes, all in contravention of Article 49, paragraph 6 of the Fourth Geneva Convention. The practice of demolitions results in the forcible transfer or forced eviction of Palestinians and impedes a de facto return of Palestinian families and communities to their original dwellings, all in contravention of international humanitarian law. Furthermore, in 2004, the Court considered that the construction of the wall and its associated regime create a fait accompli on the ground that could well become permanent, in which case it would be tantamount to a de facto annexation, as well as a contribution to further alterations of the demographic compositions of the OPTs. Articles 47, 49, 52, 53, and 59 of the Fourth Geneva Convention remain applicable to the OPTs and are to be taken into account in this case. Spain is of the view that neither Article 51 of the United Nations Charter nor the state of necessity have any relevance in this case in order to preclude the wrongfulness of those actions. Mr. President, let me now invite you to give the floor to Professor Santiago Ripoll, Head of the International Legal Office.
I thank Mr. Pinn, and I'll give the floor to Professor Ripoll. You have the floor.
Mr. President, distinguished members of the Court, what are the legal consequences arising from the repeated, permanent, and aggravated non-compliance of core rules of international law. This is the question the General Assembly requested to the Court. When this question is examined from the perspective of the law of state responsibility, the importance of the advisory opinion becomes critical. Articles 40 and 41 of the 2001 draft articles on responsibility of states for internationally wrongful acts answer this question. According to these articles, a serious breach of an obligation established for the protection of the interest of the international community as a whole entails the legal consequences stipulated for all breaches of international law, and some particular consequences. Therefore, the responsible state is obliged to cease the wrongful act, to give, if appropriate, guarantees and assurances of non-repetition, and to make reparation. Moreover, the responsible state is bound to continue performance of the international obligation. On the other hand, failure to comply with international obligations gives also rise to the right for the injured state to seek redress or take countermeasures. However, it has been said, Article 41 states that besides these ordinary consequences, serious breaches of jus cogens rules gives rise to some additional particular consequences, which, generally speaking, imply certain obligations for all other states to respond to the wrongful act, namely, obligation to cooperate with and bring to an end the alleged violation, obligation not to recognize the legal situation, and obligation not to render aid or assistance in maintaining the situation. Mr. President, my intervention will focus on these particular obligations of all states, other than the injured states. In its 2004 advisory opinion on the war, the Court briefly referred to these additional consequences. 20 years later, with the worsening of the situation in the occupied Palestinian territories, the Court is called upon to set out in greater detail these obligations. Mr. President, distinguished members of the Court, the duty to cooperate to bring to an end remains the first obligation of the states, according to Article 41 of the draft articles. This obligation to cooperate shall be carried out by all states. In the Israeli-Palestinian conflict, cooperation among all states has been organized in the framework of the United Nations. Once again, 20 years after the advisory opinion on the wall was passed, it is an indisputable reality that the situation in Palestine has worsened and that resolutions of the Security Council and the General Assembly have repeatedly condemned the actions of the parties and repeatedly demanded the cessation of the violations of international law. However, such resolutions have failed to establish redress and sanction measures. Therefore, the reference of Article 41 to the action of all states becomes critical. In some way, paragraph 159 of the advisory opinion on the wall underlines this when this paragraph established that it is also for all states to take measures to end the breach. Moreover, in the comments to conclusion 19 of the draft conclusion on identification and legal consequences of peremptory norms of general international law, jus cogens, we can read that this statement suggests that over and above collective action, there is an obligation on individual states to make efforts to bring situations created by the pledge to an end. In the current circumstances, maybe the Court could determine what such an obligation to cooperate might consist of in this case. In doing so, the Court may take into consideration the numerous resolutions of the Security Council and the General Assembly, especially those resolutions stating that states are obliged not to take measures that would imply changes in the status of the occupied territories, including East Jerusalem and the Gaza Strip. Corollary is clear. Establishing diplomatic missions in the Holy City is a serious threat to the stability of peace in the region and the world. Coming back to the cooperation of all the states within the bodies of the United Nations, the Court could determine whether the obligation of all states to cooperate to bring to an end any serious violations of parental norms entails the duty within the Security Council, in particular, entails the duty to not prevent, hinder, or delay collective action in favor of the peaceful resolution of the conflict. Mr. President, let me move on now to consider the two particular duties included in Article 41, paragraph 2 of the 2001 draft articles, namely, the duty not to recognize the legal situation and the duty not to render aid or assistance in maintaining this situation. What situation? The last resolutions adopted by the Security Council and the General Assembly on the Israeli-Palestinian conflict update the scope of the current situation that should not be legally recognized. Certainly, Resolution 7488 of the General Assembly, the first one, including this formula, calls upon all states not to recognize and not to render aid or assistance in maintaining the situation created by measures that are illegal under international law, including those aimed at advancing annexation in the occupied Palestinian territory. Since these two obligations have been reiterated by the Court and other United Nations bodies in this, but also in other situations, they are to be considered as customary law, something that, by the way, the International Law Commission has already affirmed. Finally, let me, Mr. President, to refer briefly to paragraph 3 of Article 41 of the draft articles, which states that international law may recognize additional legal consequences deriving from the legal regime to which the primary rule that has been violated belongs. These particular obligations can be found either in the foundation of the legal regime in particular or Security Council resolutions. Article 47 and 146 of the Fourth Geneva Convention are good examples of obligations provided for in the foundational treatise of a particular legal regime like the international humanitarian law. While Article 47 establishes the inviolability of the rights of persons in occupied territories, Article 146 refers to the obligation of the states parties to the Convention to prosecute and condemn persons who commit or ordered to be committed any of the grave breaches of the Geneva Convention. As said, sometimes these obligations linked to a particular legal regime sometimes are specified by the Security Council itself. This is the case of Resolution 2334 of 2016, which requires the states to distinguish in their relevant dealings between the territory of the State of Israel and the territories occupied since 1967. Mr. President, distinguished members of the Court, Spain formulates these considerations within the framework of a consultative procedure, aware that the Court, guardian of international legality, can offer the United Nations arguments to adopt decisions to address the situation and, at the same time, contribute to the clarification and development of the international legal order. Thank you very much.
I thank the delegation of Spain for